Good morning, ladies and gentlemen, and welcome to our argument with the California Supreme Court. As some of you may have heard, the Chief Justice is not with us this morning as her mother has passed away. We ask you to keep her and her family in your thoughts. We thank counsel for your accommodation. The clerk may call the calendar.
Case number S233757, Bianca M, minor, etc. Petitioner versus Superior Court of Los Angeles County Respondent Gladys M, as real party interest for petitioner Mr. Joshua C. Lee. Ready. For amicus curiae, Javier Becerra, Michael J. Monga. Ready. And for amicus curiae, L. Rachel Lerman. Ready. Case number S244549, Irma Ramirez, individually and as personal representative, etc., plaintiff and appellant versus Cedar Cardina, defendant and respondent. For appellant, Mr. Abdallah Nabi. Ready. And for respondent, Ms. Ladette L. Monstan.
Ready. All right, counsel, you may proceed.
Good morning, Your Honors. My name is Kevin Rosen, and I'm here on behalf of Sheppard Mullin, Richter, and Hampton. What I'd like to do in my presentation here today is address initially the Court's question about the issue of current client, and then talk about the questions of informed consent and waiver, and then finally arbitrability. If there's time, I'll touch on the disgorgement issue. To begin with the current client question from the Court, the Court asked whether on March 4th, 2010, when Sheppard Mullin and JM signed their engagement agreement, South Tahoe was a current client of Sheppard Mullin. The answer to that question is no, because under the terms of the agreement, which best reflects the parties' intent, the current client relationship ended when the labor arbitration was undisputedly concluded in November of 2009. And in answering this question, I think it's important to keep in mind, given the procedural position that we're in, that the burden is on JM to establish that there was a current client relationship under well-settled principles of this Court and courts of appeal.
Did the firm then do work for this client some 3 weeks later?
Yes, the client, South Tahoe called Sheppard Mullin approximately 3 years.
Was there a new engagement agreement or a new engagement letter at that point signed?
There was not a new engagement agreement because, Your Honor, I think when you look at the terms of the existing engagement agreement that was in place, it's what has been described in cases such as Banning Ranch Conservancy versus Superior Court as a framework agreement. And in a framework agreement, as discussed in that case, you basically have an agreement that sets up a situation where a client may continue to make calls, but each individual matter, once it's completed, ends the current client relationship. That's what Banning Ranch discussed in its opinion.
So you're not married, but you're dating?
I'm sorry, Your Honor?
So you're not married, but you're dating? It seems like that's a little bit of having it both ways.
Well, I think, Your Honor, again, if we look at the terms of the engagement agreement, I would suggest that it's not. If the agreement itself says, among other things, that a matter automatically terminates, for example, upon its completion, and it's terminable by either party, and there's no retainer, and either side, Sheppard Mullin is free to decline a retention or an engagement, and South Tahoe is free to go to other lawyers. And we know from the record, for example, that South Tahoe used other labor lawyers, at page 277 of the record, and we know that there was at least one occasion when Mr. Dinkin declined a request by South Tahoe in May of 2011.
But help me understand, counsel, how we would generalize the point that you're making. It sounds like you're arguing that you can have a valid, in-force framework agreement, that's what you're calling it, and not have a client representation relationship, number one. Is that right?
I'm saying that if you have a framework agreement, which is a term also used in the Banning Ranch case, and you have the provisions that were contained in the engagement agreement between South Tahoe and Sheppard Mullin, including, in particular, an automatic termination provision for each matter.
And is that enough to win on this point for you, that there's an automatic termination provision?
I think it is very significant, but I think that in combined with the additional facts. For example, and I don't mean to suggest that it's a bright line absolute rule, if you have an automatic termination provision in an engagement agreement, that that's the be-all and end-all of the analysis. For example, one of the other elements of this situation was that there was no retainer agreement being held. There was no obligation on the part of Sheppard Mullin to take on a matter, which is a distinguishing factor that you see as discussed in Banning Ranch and other cases that would distinguish a framework agreement from a classic retainer agreement.
But
When
so
did the
does
conflict become apparent to Sheppard Mullin?
Well, I think Sheppard Mullin did not believe that there was a conflict.
Even though they were representing two sides?
Well, I think Sheppard Mullin, as the record indicates, Sheppard Mullin believed that, A, there wasn't a current client relationship. There was no matter going on March 4th. It had concluded in November. And when South Tahoe had called again, Sheppard Mullin reasonably believed, that they had a valid waiver from South Tahoe, thereby not creating a conflict situation.
With no obligation to talk to the clients about any looming problem?
Well, I think that goes back to the retainer agreement that Sheppard Mullin had with JM, if that's when you say the clients. With respect to South Tahoe, the waiver with respect to South Tahoe is something where Sheppard Mullin would not have an obligation to go back, because Sheppard Mullin made clear in the engagement agreement and in the waiver provision that this sort of situation may come up. Frankly, it's why firms have these, lawyers have these types of provisions to allow this sort of relationship to continue, whether it be, and we'll talk about it in a little bit in terms of advance waivers, but whether it be a framework agreement or the issue of advance waivers, the idea is to allow a client to be able to use a firm of its choice, as long as there's appropriate informed consent and the other elements that go with it. But it allows the client to use the firm of its choice. Think about from the standpoint of a framework agreement. You could set up a scenario where each time a matter ends, rather than providing in the contract that the termination, it automatically terminates, some have suggested, well, you should just send out a termination letter. I would submit that having a provision in the contract that obviates the need for that changes that. But if you do that,
even if Sheppard Mullin's position in counsel is that there was no conflict here, is it good practice to tell a client that a framework agreement is in place with an entity that might arguably create a conflict?
Well, I think when you say tell a party that a framework agreement is in place, you're referring
Yes.
to JM.
Correct.
In your question. Well, I think that gets to the question of informed consent and well. And in that situation, I think you also have to look at what was said. And so what I mean by that is, if the engagement agreement between Sheppard Mullin and JM says, for example, we may currently or in the future or in the past represent or have represented someone, anyone, including any of the 200 key TAM real parties in interest. That's a fairly comprehensive statement. Built within that, of course, is the possibility that one or more of those 200 may currently or in the future be clients. And if JM, who is, or really JM's lawyer, and we talked about that in the briefing, a party represented by counsel that's sophisticated, if they're in a situation where they have been told that a lawyer for the sophisticated client has been told we may currently represent, or in the future we may represent
Well,
anyone
I think
adverse to you.
there's no question about those provisions, and I guess there is some disagreement about what a reasonably sophisticated actor should infer from reading those. But I want to still go back to try to understand the framework agreement. Is there any time limit on the framework agreement?
There doesn't have to be.
Is there in this case? Does it just sort of exist in perpetuity?
Until either party elects to terminate, which is
the
also
actual
a provision. But I think, in answering that, I think it's important to remember we're talking about a framework. So when you say it's in perpetuity, it's in the context where you also have a specific provision that a matter terminates upon completion.
Okay. So during these periods of dormancy, let's say, when there is no active client representation matter, what kind of duties does the law firm owe to the dormant client during that period?
The law firm owes a duty to maintain the client's confidences, for example. The law firm owes a duty not to become adverse to that client.
That's what I was going to ask you. Can the
unrelated
law
matters.
firm take on a matter adverse to the dormant client?
If you have a framework agreement that also has an advance waiver provision, you could, consistent with what's being waived.
Do you have to give notice?
It depends, again, on what the provision in the advance waiver provides. But the whole point of an advance waiver, for example, if a client is agreeing that in the future I may be able to represent someone adverse to you, they're always going to say, and they said here in both instances, unrelated, and as long as it doesn't involve
Could you
confidential
represent an
information.
entity that was going to sue the dormant client?
That's what if you provide for it in the waiver, which is what was provided for here.
I mean, it seems like you'd have to give them some notice, don't you think? I mean, you wouldn't want something to transpire in this interim, and then the dormant client sort of finds out about it after the fact. That doesn't sound ethical, does it? I mean, the idea that you have retained an agreement with somebody, and meanwhile, you're kind of going behind their back in a way, not intentionally, but I'm just saying you're going behind their back to do something adverse to them, and you don't even let them know until the next time they call you for a matter, and then you say, oh, by the way, you may want to know that we're representing this other entity in a matter adverse to you right now. That seems a little, that doesn't sound right to me.
Well, Your Honor, I think I would respectfully disagree with that characterization of going around their back. And the reason I would say that is if you have an agreement that specifically calls out the fact, two things, and I think what we're doing is we're combining two elements of this agreement that existed with South Tahoe, if that's the question. There's the framework element of it, and then there's the waiver element. The analysis is a little different, in connection with your question, if there is or isn't a waiver provision in there as well. But if you, and remember, the idea of the framework agreement, just to step back, there is a reason for it. It does say, for example, a client that has an internal process that has to have an engagement agreement approved, and it can be cumbersome. Client may prefer to just say, look, we'll use the same agreement each time I call you, and I recognize, both sides recognize we don't want to be in a current client situation by having to send out termination letters, so let's set it up that way, which parties are free to do. An attorney-client relationship is a product of contract. That's what this contract does. In addition, this contract says, look, at any point in time, while we're representing you or the dormant period, that's what an advance waiver is. In both periods, not necessarily limited just to the dormant period, we may be adverse to you. And it has, we can run through the waiver. But look, we may be adverse to you, recognize, and there are provisions here, recognize that has an impact on the duty of loyalty, recognize that could affect your need to get other counsel, there could be costs and delays associated with that, recognize all of that, and the scope of the waiver is anything that we're, as long as it's not related to precisely what we're doing and we're protecting confidences and all that, then, and also South Tahoe is told that this, in terms of the scope of the waiver. The scope of the waiver is, it's not just I may give advice to somebody, it's not just I may do a transaction, I may be on the opposite side of a transaction with you. It's as broad as I may also be in litigation adverse to you.
So we've gotten to the advanced waiver issue, and we'll want to talk more about that, no doubt. But just to make sure I understand you, when you say that the client relationship is a creature of the contract, or I'm trying to remember the exact words you used, it sounds like, from your perspective, a lot of the ethical provisions that might relate to the relationship between a client and a lawyer are default rules that can be simply cast aside by contract. What are the limits of that?
Well, I'm not sure I would characterize it as cast aside. I would call it what happens all the time, which is if it's a waivable right and a client waives it, under appropriate circumstances, I wouldn't characterize it as casting it aside.
So appropriate circumstances, let's unpack that. What is the obligation of the lawyer to provide information to a client before or during the process of the client deciding whether to waive a right?
Well, that gets to the question of informed consent. In terms of if you're talking about waiving a right with respect to a conflict. If we're talking about something else, then we can address
Let's start with a conflict.
Okay, with respect to a conflict, the obligation is to make sure, fundamentally, when we talk about waiver and the test for waiver, we're focused on what does the client reasonably understand. And the best place to start with what a client reasonably understands is in the written agreement that the client signed, particularly since informed consent is based off written disclosure. So we start with the writing. And if the writing calls out the fact in the context of a framework agreement with South Tahoe where we're going to provide you periodically as you request if we agree, again, in contrast to classic retainer agreements, and that's important. In a classic retainer agreement situation, a law firm is obligated in some way, and they specifically call out the obligation to take on the matter. And the client has, and they limit their ability to say no. And so in this situation with South Tahoe where that circumstance existed, if South Tahoe in the contract is told that during the period of time we're providing you with labor advice, which will be sporadic, or during the dormancy period, we may be adverse to you in various ways, broadly defined to include the largest component of adversity, which would be adversity in litigation, again, unrelated, in confidence protected. Then the client reasonably understands the circumstances. I will give you advice when I finish the matter. In this case, it was a labor arbitration in November of 2009. When I finish that matter, the relationship is terminated under the terms of the agreement in that sense. But if you call me again, we have a framework in place, of course, unless we choose to amend the contract. And during both the period of time where I may be providing advice and during the dormancy period, I may be adverse to you in these various ways that are laid out in the agreement.
Had Sheppard Mullin, before the date it entered into the engagement with JM, had it ever turned down a matter from South Tahoe?
Before the date of the engagement agreement with JM, I don't think there's evidence in the record.
You pointed to an incident in May 2011. What was the circumstance? What were the circumstances there?
Well, to answer your question, I don't believe there's in the record an example prior to March of 2010.
Okay.
The circumstances in May of 2011 were that South Tahoe had asserted that there was a conflict.
So does the course of dealing, so the fact that over time a law firm repeatedly accepts a matter when it comes in and doesn't exercise whatever implicit right there may be to turn down the matter, whenever the client calls, that the lawyer takes the call, does that bear at all on whether the attorney-client relationship is a current one as opposed to a dormant one, as you're using the term?
Sure, I understand. I think the answer to that question in the context of a case like this where a contract specifically tells us what the situation is, the answer is no.
Does the contract specifically say anything about Sheppard Mullin's right to turn down work?
The contract specifically says that Sheppard Mullin, that unless we agree otherwise, our representation will terminate upon completion of the matter. The agreement provides that Sheppard Mullin may terminate an existing matter if it wishes, and it provides that South Tahoe has the right to terminate any matter, and of course South Tahoe has the right to simply not call Sheppard Mullin. And I would say, while the agreement doesn't have the words, we don't have to take on a matter for you, I think in terms of what somebody reasonably understands, one would understand that if you call and for some reason we can't or won't, for example, I mean, if there's a call and it's determined for some reason, take the labor arbitration for a second. I don't think you have to have a specific provision in the contract to say we won't take on that labor arbitration if you go back in time because, for example, we have a conflict. So I don't think it's necessary to have a specific provision in the contract to say we're not obligated to take on a matter for you, when number one, I think a reasonable person would understand that, but beyond that, the contractual provisions talk about how the agreement will or our representation will terminate upon completion of the matter.
So can I ask you a broader question? So we've been talking about client relationships in 3 categories so far, so current, former, and then you're suggesting that there's a sort of middle category of sort of a little bit of each. Somebody who's a little bit of a former client, but also everybody recognizes could become a current client, at a phone call's notice. Is that a distinction? Is that category of dormant client relationships something for which there is authority that describes a sort of a distinct set of ethical obligations?
There is certainly a body of authority that talks about that dormant period and the current former client distinction. But those cases aren't talking about that period in the context of a framework agreement. And I think that's the fundamental distinction. Just like anything else, if that's the general body of law absent a framework agreement, signed and agreed to by both parties in a contractual relationship, which is what an attorney-client relationship is at the end of the day, then those cases aren't applicable to the dormant period. What's applicable is what the parties agreed to. And so all of the case law that's been cited and otherwise exists that talk about that dormancy period in other contexts don't apply when the parties specifically contracted that dormancy period would have a particular status as between them. What I'd like to do, if I may, I certainly would like to continue making it clear where our position is, and I think I'll just say simply, the combination, if you go back and you look at the framework agreement and the provisions that talk about automatic termination, no retainer or any obligation on the part of either party to do anything, as well as unrebutted evidence in the record from Mr. Dinkin at page 277 that the purpose of this agreement was to avoid having to deal with separate retainers each and every time the district had a discrete employment-related question. It's the totality of those circumstances in this particular case, consistent with what Banning Ranch described as a framework agreement, that render the dormancy period, which there's no dispute the parties were in March of 2010, as not a current client situation. On the question of informed consent, and we touched on that a little bit.
May I ask you a question?
Of course, Your Honor.
Did Sheppard Mullin ever inform JM that it had previously represented South Tahoe prior to at the time of engagement?
The direct answer to your question, Your Honor, is not in those words.
Well, tell me what words.
Okay. I think when you look at what is disclosed, the disclosures in the engagement agreement with JM, among other things, Sheppard Mullin has said to JM's lawyer, counsel for a sophisticated party, a number of things, including calling out specifically the Ketam action with its 200 real parties in interest, that they may, and this is really goes most directly to your question, they may currently, in the past or in the future, represent anyone, including any of these 200.
But Sheppard Mullin had that information. Why didn't they just tell JM, we have previously engaged South Tahoe? Why did they do that?
Well, I think Sheppard Mullin viewed its disclosure as being broad, again, to a lawyer representing a sophisticated client. And I keep saying that because I think that's critically important to keep in mind. We are not talking about a circumstance where someone is unrepresented. So Sheppard Mullin tells JM's lawyer, who is admittedly experienced in these areas, that we may currently represent any one of these 200.
I understand
Built
that,
within
but
that.
having that information, why wasn't it disclosed?
Well, the problem with that approach is, you start large and you funnel down. You start you say, look, we may currently represent, again, you have to keep in mind as well the context here. This is not a situation where there's one plaintiff, one party on the other side, and there's an active matter. You have 200 plus parties on the other side.
Well, counsel, we understand it's complicated. There are a lot of people involved. It's hard to figure out who to tell what to whom. But when you find out that you're representing two parties in a litigation, as Justice Liu says, isn't there a duty to give notice?
Well, first of all,
rather than hiding it under all of this complexity?
Well, first of all, Sheppard Mullin wasn't at the time currently representing South Tahoe. They weren't actively involved in any matter with South Tahoe. And the issue here, when you're in a situation like that, if you start calling out specific names, if the client, given an agreement that says, or a lawyer, given an agreement that says, we may currently represent any one of these people, and the lawyer says, doesn't care, there's no objection to it whatsoever, then once you start down the road of, okay, well, the client is okay with us currently representing somebody in this matter and our ability to represent anyone in the future.
I understand your state of mind when the parties enter into this agreement. But farther down the road, you find out there's conflict. When you find that out, isn't there a duty to notify the other side?
There isn't if there's a waiver. And keep in mind, when we...
But that was signed before any of this occurred. Now, down the road, you find there's a conflict. When you find that out, you still have no duty? You're hiding under the contract that was entered into in some prior time.
With that question ringing in your ears, let me just let you know that you're eating into your rebuttal time. You may choose to do so if you like. You have 5 minutes left.
I appreciate
that. And you can either answer it now or answer it later.
I appreciate that.
I don't want to cut into your time.
No, I appreciate that. I'd like to answer that now. I guess I would respectfully disagree with the proposition about hiding behind. And keep in mind, for example, one of the reasons one gets an advance waiver is because down the road when a matter comes up, look, if you're talking about a downstream obligation, when you have a valid advance waiver, let's assume for a moment you've got a valid advance waiver. If you have a downstream obligation, nevertheless, to notify the client who provided the waiver, you're cutting significantly into the efficacy and value, both for clients and lawyers, of the waiver. For example, if the downstream representation is a confidential matter for that client, without a waiver, you obviously have a duty to advise. And if you can't advise because of confidentiality, you can't take it. But with a waiver, the point of the waiver is to obviate the need for any downstream notification. So that, for example, I get an advance waiver from you if a client calls and wants me to conduct, or a different client calls and wants me to conduct a confidential investigation. I don't have to go back to the client who provided the waiver. There's need and value in not having to go back. And if you do have to go back, what does that mean? Does that mean that the client, positing a valid waiver, if you go back, does that mean that the client has the ability to say, well, I don't agree anymore?
I think absolutely. I mean, isn't that the value of the notice? Is that you set up a framework that says, I mean, not to take the dating analogy too far, but you say you're free to date other people. Just let me know if you do, right? I mean, that people like to know because it may alter their behavior. It may cause them to reevaluate the situation, especially when you're in an agreement with somebody. You say the framework agreement is operative, right? And if you are then come into some new information, you may wish to reevaluate whether you want to keep this framework agreement because perhaps you should have a framework agreement with someone else at that point, instead of waiting until a matter arises for which you need legal help and then realizing after the fact, oh, there is some adversity here that is too much. Isn't that the value of the notice? It is not at all inconsistent with the idea, everything you've said, which is perfectly fine, that there is this waiver and that gives a certain amount of understanding on both sides, but there is additional value to the notice.
Well, again, I would go to whether there could be, but it really is defined by what the parties agree to. And the point of an advance waiver in a situation is that you don't need to do that because in many instances you can't. And if you open up the proposition that you have to go back and speak to the client about it when the client has already said, I'm fine if in the future you are adverse and against me in all these different matters, then it opens up the door to problems that undermine the value of the advance waiver. I would like to hold on to at least a couple of minutes if I could.
You have
for
3
rebuttal.
minutes.
Thank you, Your Honors.
Mr. Richland, and while you're getting set, let me acknowledge an oversight on my part. I neglected to announce and thank that we are joined this morning by the Honorable Gilbert Ramirez, Associate Justice of the 4th Appellate District.
Thank you. Good morning, Your Honors, and may it please the Court. I do want to address first, as Mr. Rosen did, this issue of whether there was a current client. But first, I'd like to just emphasize the magnitude of what the argument that's being made here. You know, reading the briefs, particularly the briefs of the law firm Amici and of Sheppard here, what they are arguing, and they argue it repeatedly, is that the realities of the modern legal marketplace, that's the phrase that they use over and over again, have now made it impossible for us to comply with what we have always understood to be the fundamental duties of disclosure of a lawyer. They're not just arguing for this advance waiver kind of notion, that there can be a blind advance waiver, which apparently is acceptable in some jurisdictions. They're saying there can be a blind current waiver. They're saying even if there is a current conflict, and as I will explain, there was a current conflict here. All we have to do is say, you know what, we may, or maybe we won't. We don't have a current conflict with you.
So even if there is a current conflict, there is no duty to give notice?
That is their argument. That is their position.
I mean, one difficulty, it seems to me, with the position is that your client, which was a sophisticated entity, well represented in the negotiations with Sheppard Mullin, did in fact agree to that term. It agreed to waive existing conflicts, having a good idea of what that entailed.
And that it was perfectly appropriate to give that kind of information and consistent with the rules of professional conduct. That's their position. They want this court's blessing for having done that. And my point is that it is inconsistent with the rules of professional conduct as we've always understood them, and that to the extent some jurisdictions, the ABA, the DC Bar, have given a blessing to advance waivers, those are only in a situation where there is no current conflict, where they don't have specific knowledge, as they did here, of another client with whom they were represented, who is contra to the new client.
So Sheppard Mullin here argues that there was no current conflict. That there was
Yes,
a sort of
that is their
on-again,
position.
off-again attorney-client relationship with South Tahoe. Why is that incorrect?
Let me explain. Thank you, Your Honor. I want to start with the notion that the existence of attorney-client relationship is, of course, a question of law where there's no dispute in the facts, and it is governed by the agreement between the attorney and the client. And an important factor, too, is that, as in all contracts, the contract is construed against the drafter, here the attorneys, and particularly where the drafters are attorneys. So it is interpreted favorably to the client and against the attorney. What we have here is that in June 2006, there was a written agreement between South Tahoe and Sheppard, and that agreement states that Sheppard would, quote, represent South Tahoe in connection with general employment matters. Represent in connection with general employment matters. And then importantly, after that it defined a term. It said, parentheses, the capital M matter. So the capital M matter was the representation of South Tahoe with respect to general employment matters. The contract then goes on and says termination of representation specifically. How do we terminate this representation with respect to general employment matters? Several ways. Number one, either party can terminate at any time. Sheppard must give notice in order to terminate. That sounds very much as if what they're talking about is representation over a period of time that ends only when one of the parties states that they are ending it.
Does it make any difference that the engagement agreement, if
Yes.
that's what you want to call it,
Yes.
describes itself as relating to employment matters in the plural, and then later in these provisions uses matter in the singular, suggesting that there may be multiple matters that are addressed by the overall framework of the
General
agreement?
employment matters are within the scope of this agreement. And what I want to say is that distinguishes this agreement from the framework agreement that the court in Banning talked about, because this agreement defines representation in general employment matters as the matter as to which this agreement is addressing. That general representation is the matter.
But wouldn't it
The
be also
capital M
possible?
matter.
But wouldn't it be possible also to read it as supplying a framework for multiple employment matters, plural?
Well, it's very difficult to read it that way because it does not have any specific provisions that were like the provisions in the Banning case that the court in Banning held were absolutely critical to finding that that was a framework agreement. And that is, there were two things in the Banning case. It said, number one, this agreement specifically says that you will come to us with individual matters, you the client, we the law firm, and we have the right to turn down any of those specific matters. Stated that specifically. And number two, it said we can do that for any number of reasons, and we will do a conflict check every time you come to us with a new matter. And we will make a determination as to whether we can now represent you with respect to that matter. That's a framework agreement, because the only part of that agreement that continues is the part that says, and if we agree to represent you, here's the terms and conditions under which we represent you. That's to be distinguished from the agreement here, which said, we are representing you now. You are our client with respect to general employment matters. There is nothing in this agreement about us doing a conflict check every time you come to us with a new matter. There's nothing in this agreement about us being able to decide not to represent you with respect to them. We're here for you. Until either you or we end the relationship, end the representation, that's what they're talking about, representation, an overarching term. The representation continues. So this is truly worlds away from the Banning type framework agreement. This is an agreement which read most favorably to the client, which of course is the appropriate way of reading it, certainly suggests that this was a continuing attorney-client relationship unless and until one party or the other ended it. And it is true that then one provision of the agreement says, unless we agree to render other legal services to South Tahoe, that presumably is other than this representation with respect to employment matters, our representation will terminate upon completion of the capital M matter. The capital M matter. That is, including all of those matters that we would represent you as to. So someone has to say, we don't have any more individual matters in order to end the representation.
So it's your position, counsel, that there was no dormant period?
That's correct. There was no
Now,
dormant.
assume for sake of argument that we disagree. At some later point in time, did there arise a duty on the part of Sheppard Mullin to give notice?
Well, certainly there was a duty originally. There was also a duty under the rules of professional conduct, even if South Tahoe wasn't a client. There was a duty to explain. And that is under a rule of professional conduct 310B1, which says that no representation may be undertaken without disclosing that you have a, quote, legal, professional business, financial, or personal relationship with a party, with an opposing party in the matter. So even if they're not a client, there has to be disclosure, at least, of the fact that these people are in at least a business or financial relationship with Sheppard Mullin.
And
Would you make
at
the
what
same
point in
argument?
time did that occur?
Well, that occurred no later than June 27, 2006. In fact, there was an earlier agreement between South Tahoe and Sheppard in 2002, I believe. So it had been ongoing for 9 years, that business relationship with Sheppard Mullin.
Would you make the same argument if it were clear that there were no longer any outstanding engagement agreements between Sheppard Mullin and South Tahoe? If it were clear that South Tahoe really were a former client on that date, would there still be an obligation to disclose?
To disclose that they were a former client?
Yeah.
You know what, we haven't concentrated on that in this case, but it seems to me that if there were a former business relationship which could conceivably affect the ability of the attorney to be able to represent the client, that has to be disclosed too under other provisions.
But would Sheppard Mullin be empowered to make that judgment about whether it could conceivably affect the representation?
They're
So here
required to under Rule 310. If there's any factor that would in some way undermine their ability to represent the client, they have to disclose.
So if Sheppard Mullin makes the judgment that this representation of JM and the key TAM action is so unrelated to anything we've done before for South Tahoe that there's really no possibility of a former client conflict, there's no obligation
I
to
think
disclose.
that's fair enough, yes.
So let's assume for a moment that we accept your argument on these points. What was the actual harm to JM, and why shouldn't some kind of quantum merit recovery be allowed?
Well, a couple of things. Number one, the actual harm to JM was the natural harm that would flow from having to substitute one lawyer for another in a highly complicated case. There was no agreement here by JM that it didn't suffer harm. The agreement here by JM was that it wouldn't pursue any actual damages. But there is no question that there is harm when your lawyer who's been representing you for a year and a half in highly complicated litigation, when that lawyer is removed involuntarily, there's going to be harm. You're going to suffer harm. Number two, the real problem here is, and the cases talk about this over and over again, is that when you're talking about a conflict of interest and a lawyer representing two parties who are against each other, but that lawyer is the lawyer for both parties, the real issue is, how can I trust that what my lawyer is doing is always going to be in my best interest? How do I know for sure that they're not pulling punches a little bit? Because after all, this other party is also their client. How do I know that they're not, even unconsciously going easy on that person, on that party, who they know is also spending money at the firm, helping to support the firm? You can't know.
Are there enough facts on this? Are there enough facts on this record to make that determination, or should we send it back to the trial court?
I don't think you can ever make that determination, Your Honor. That's the problem, is that it's really impossible for a party to prove.
So what should this court do?
I think what this court has to do is follow the case law that has been decided in this case for at least 30 years, and that is where there is a direct conflict. It's not a question of what is the amount of the damage. It is a question of the fact, and this court said it in Huskinson, these people, the lawyers, are seeking compensation for prohibited conduct, for conduct that is directly prohibited by the rules of professional conduct. And they're not permitted to do that. That's what Jeffrey versus Pound said. That's what this court said in Huskinson and Brown. It said, that there may be no recovery for value of services in cases involving, quote, violations of a rule that prescribed the very conduct for which compensation is thought i.e., the rule prohibiting attorneys from engaging in conflicting representations or accepting professional employment services adverse to the interest of a client or former client without the written consent of both parties. That's in Huskinson and Brown, 32 Cal 4th, 453.
So here there was written consent. The argument you're making is that it wasn't adequately informed consent.
That's correct.
Are there any cases that address whether a lawyer is entitled to some measure of compensation, if not the full value of the contract expectation, in a case where there may have been a mistake, if inadvertent, in making the disclosures required for informed consent?
I don't think that mistake or inadvertence is the issue.
Well,
Your
but
Honor.
the question, but I think
I
the rule that
understand.
you're arguing for would cover mistake or inadvertence too.
The difficulty is because the duty of loyalty goes to the very heart of the attorney-client relationship. Where there is a direct violation of that duty by representing conflicting interests, the cases are uniform. Jeffrey versus Pounds, Goldstein
But
versus
I
Lee.
repeat the question, but none of those cases had to do
But
with...
there are other cases that say yes, under some circumstances, where there are lesser violations, where there are violations of rules of professional conduct that are technical, for example, or that go to some issue that is less central to the attorney-client relationship. Yes, under those circumstances, there can be a weighing and balancing. A determination to quantum merit is available.
But you mentioned the Huskinson's case. That was a fee dispute, correct?
Yes, it was.
And it was not between a lawyer and a client. It was between two law firms.
Correct.
So is that really on all fours?
Well, it is in the sense that what this court said in Huskinson is, under those circumstances, there can be some recovery. And it contrasted that with the quotation that I just gave you, saying we're perfectly aware that where there's a direct conflict and where therefore the services that are being rendered are exactly those that are prohibited, acting as a lawyer with a conflict, that there can be no recovery under those circumstances. And we're contrasting that with the situation in our case, Huskinson, which involves simply a fee dispute. And yes, a violation of the rules of ethics, but not something that is so central to the attorney-client relationship.
Why did your client agree to enter into an engagement agreement that waived the duty of loyalty for this purpose and agreed to waive existing as well as future conflicts?
Your Honor, that does not appear in the record. The reason for doing so doesn't appear in the record. But let me say this. Any client, no matter how sophisticated, no matter if they are represented by in-house counsel, which was the representative in this case, not independent counsel, but in-house counsel, when they come to a lawyer and they are being sued for literally billions of dollars, and they have been, as they were here, dissatisfied with their former representation and really need help in a terrible, terrible situation for the company, they're in a weak position automatically, no matter how sophisticated they are. And when they come to lawyers who they respect and who they talk to and who are impressing them with their abilities and what they've done in the past and what they're able to do for them in the future, they're in a position where it is not easy to decide precisely what are the boundaries here. It is one thing to talk about fees, which are tangible. It's quite something else where you're talking about conflicts of interest, and whereas the record here shows, the lawyers come to you and say, don't worry, no conflicts. So when you sign something and someone has told you no conflicts, and it says, we may have a conflict, we may have one in the future, gee, under all those circumstances where you really want those lawyers to represent you, it's pretty understandable that you might sign something like this. Notwithstanding the fact that if they had a legal ethics expert along with them, the legal ethics expert would have said, wait a minute, this doesn't tell you anything. If they're saying they might have a current conflict, but it doesn't tell you anything about who that might be. Who knows who that might be? That might be the biggest heavyweight who's against you in this case, and that's their client too. That's pretty troubling that could be covered up. And not only that, when I say covered up, that's what happened here. there was a disparity in information between what Sheppard Mullin knew and what their putative client knew. Well, there's something really sort of fundamentally wrong with that, isn't there? For them to know about this client and not disclose that, what possible motive could there be not to disclose that information? It's hard to imagine, but it must be, gee, this might turn the client off. If we told them the details here, maybe they wouldn't be so enthusiastic about hiring us.
So briefly, what did your client believe was being waived when that waiver provision was agreed to?
Well, Your Honor, who knows? It's not, as I say, it's not in the record. I've described the situation, the circumstances.
Right? I mean, there was some understanding that something was being waived.
Something was being waived, and I guess the thought was, well, I'm not waiving current conflicts. There certainly couldn't be any of those because they just told me there weren't any.
Even though the language of the engagement agreement says just that.
Even though the agreement says yes. Even though the agreement says we may have current conflicts. Under those circumstances, I think they must have believed, there's a chance that at some point in the future there might be some kind of conflicting representation, but I believe in these people, and I don't think that they're going to do wrong to me. I'm sold. They're going to do their best for me, notwithstanding that. I mean, the problem is
so
that
I'm waiving these rights, but they're not going to take advantage of that because they're good people. That's
right. I think that's I think what you have to assume when you're hiring lawyers who you're putting actually the fate of the company into their hands. I mean, what else can you believe? What else can you believe under those circumstances? Let me briefly discuss the arbitration issue, which I think is sort of a threshold issue here, and unless the court doesn't have questions, but I would like to briefly state that essentially what we are dealing with here is something that the Moncharge case already dealt with. The Moncharge case, you will recall, said there are two different kinds of illegality situations that can arise in a contract that includes an arbitration clause. One is where there's a claim that a specific provision of the contract is illegal, and the other is where there's a claim that the entire contract is illegal. And what the Moncharge court said was the legislature's already dealt with this. And the legislature says that where there's a claim that there's a specific provision of the contract that's illegal, that's just the kind of issue that the arbitrators are going to have to decide. As long as we're not talking about the arbitration clause itself, the arbitrator has to decide that issue, and that's decided under CCP sections 1286.2 and 1286.6, the vacatur provisions that say, you're very deferential courts to what the arbitrators decide. And if they've decided there's a provision that's illegal, by and large, Moncharge says, by and large, you have to say, even if you're wrong, even if you're clearly wrong, we have to agree with that, except in a very, very narrow circumstance, and that is where there's a statute that says as a matter of public policy that's illegal. And you have to then follow that statute because the presumption is the legislature would have wanted that to overrule that particular provision. But Moncharge also says the legislature wants contracts that are entirely illegal to be treated differently, to be treated under CCP sections 1281 and 1281.2, because it says as to those, that's an issue for the court to decide in the first instance. And as this court held in the Loving case, the court then decides at the very beginning of the process, should this contract be entirely illegal, then that's the end. It doesn't go to an arbitrator who, incidentally, might hold an entirely illegal contract that is contrary to the fundamental public policy of the state of California, might just say, this is perfectly legal. Courts can't do that. Courts have to say, if you've got an entirely illegal contract here, that's the end. We're going to say it can't go any further. Now, in this case, of course, what happened was the court at first held that it was not illegal. It then went up to the arbitrator. The arbitrator made a decision, but it never should have, because when it came back to the courts in an attempt to confirm the arbitration award, the court said, well, now we're looking at this and we conclude, yes, it was illegal. This was an illegal contract, and it should never have gone to the arbitrator in the first place. So there's no deference to what the arbitrators decided here, because it should never have been there. This is not an issue that the arbitrators should have been deciding. Unless there are further questions, I'm going to submit them. Thank you, Your Honors.
Thank you, Mr. Richter. Oh. Try not to break our equipment.
Counsel, your friend on the other side addressed the quantum merit issue. Could you respond to Mr. Richland's argument regarding quantum merit and his citation of the Hutchinson-Brown case?
Absolutely, Your Honor. I just will point out the discussion about Rule 3310B. That was something that, as the Court of Appeal noted, was never addressed, briefed, raised anywhere in the Court of Appeal or in this court. With respect to disgorgement, two things. First of all, the question was asked about damages, which of course are something that is required for purposes of disgorgement under this court's decision in Fry and under the Slavinsky case. And in the procedural context of this case, it's JM's burden to establish damages. And to say, well, we stipulated just for this reason or that reason, that may be fine. But in any point in the process, including in opposition to the petition to confirm the arbitration award, they had an obligation to introduce evidence to support the proposition that disgorgement was improper. And without evidence of damages, it was their burden to introduce. They can't get disgorgement under those two decisions. With respect more broadly, and the court's question about, or Your Honor's question about Huskinson, proportionality, flexibility, and fairness has always been the standard in this state. That goes all the way back to Clark versus Millsap. It's reflected. Fry from this court talks about proportionality. There are multiple Court of Appeal decisions in Matarosian and Pringle. The restatement talks about proportionality. To the extent you adopt the per se rule, you implicate constitutional due process issues because it becomes punitive. And the egregiousness standard that exists.
So you think it would be too harsh?
It's not a question of too harsh. It's a question of what are the existing standards that have been in place in California. And as I'm saying, going back to Clark versus Millsap, it has always been a test of egregiousness and the appropriateness under the circumstances and the facts of any particular case. That's not novel. That's the appropriate way to approach it. That takes care of the Huskinson. All Huskinson did was note the fact that there were two cases out there from the Court of Appeal that said, no, if there's a conflict, then there's no
Was one of them Goldstein?
One of them is Goldstein, and Goldstein involved the egregious situation of using a client's confidences against the client, I believe, in a substantially related matter.
But wasn't that case, was in Goldstein, didn't the client go to the attorney specifically to get inside information on the corporation?
Yes, it was an egregious breach of confidential information from a client that doesn't exist here.
In this case, it's true that's not quite what we have here, but shouldn't it be your burden to demonstrate that there is no possibility of, assuming there were a conflict, that the conflict did affect the representation of JM? The other side says that, well, you can never know. You can really never know. So they would like a bright line rule. But if we adopt a more flexible rule, at least shouldn't the burden be on the attorney who has defaulted on the duty of loyalty to demonstrate no reasonable possibility of material harm to the client?
Well, I'm not sure. Two things. One is in the context, the procedural context of this case. First, the issue was addressed in the arbitration, and so procedurally here, the issue is, what basis is there for, what evidence is there in support of overturning that? in the broader sense, I don't think the test is, I think the test is what it has always been, and the appropriate test should be what it has always been, which is a balancing of a number of factors, commonly referred to as egregiousness, and adopting that. Huskinson says nothing different. Clark and Fry do talk about proportionality. I think if you adhere to a proportionality, you also avoid the constitutional issue of turning this question into an issue of punitives.
But I think the question is, insofar as one of the components of the proportionality inquiry consists of the harm to the client of the attorney's divided duty of loyalty, what would be wrong with placing the burden on the attorney to show that the adverse representation had no effect on the attorney-client relationship?
Well, I think as a
you may
practical
answer that question, and then your time has expired.
I think as a practical matter, to the extent the claim is for quantum merit, there would be an obligation on the part of the party to meet whatever burdens come with quantum merit anyway. And so I think in the procedural context of that situation, it would be addressed without changing anything. May I have just 30 seconds to address the arbitration, just a quick arbitration point, Your Honor? Thank you. What I wanted to say on arbitration is this is not a JM agrees that if it's partial illegality under Monkarsh, they lose. Their entire argument is based on complete illegality. And there isn't complete illegality here because the engagement agreement, not just on its face, but as applied, governed multiple matters. And specifically, I'm referring to Sheppard Mullin's work for JM on the class action that's referenced at pages 230 and 495 of the record. So if the engagement agreement applies to the key TAM action, which is the issue that we've been talking in the case, and the engagement agreement, not just on its face, but as applied, governed a class action, which did not involve South Tahoe. South Tahoe was defined to be excluded from that class. The entire agreement can't be illegal. And if the entire agreement can't be illegal, then under JM's own acknowledgement on page 1 of their brief, we have partial illegality, which means under Monkarsh, their argument about judicial review goes away. Thank you, Your Honor, for your indulgence.
Thank you, gentlemen. The matter will stand submitted, and thank you, Justice Norris. In the matter of Bianca M. versus the Superior Court of Los Angeles, Gladys M., real party and interest. In this matter, the court is joined by the Honorable Judith D. McConnell, Administrator Presiding Justice of Division 4. Counsel, you may proceed.
Good morning, Your Honors. May it please the Court. I'd like to focus on two issues raised by the lower court's decisions in this case. The first is the decision to require Bianca's alleged father, Jorge, to submit to a paternity determination as a condition of making a finding that Jorge abandoned Bianca, and also as a condition of awarding custody of Bianca to her mother. And the second is the Court of Appeals' determination that Bianca was not entitled to SIJ findings, Special Immigrant Juvenile Status findings, because the court believed that getting those findings was her primary motive for bringing her custody action. I think some context is helpful to understand why those two decisions are so problematic here. Bianca's alleged father, Jorge, abandoned her before she was born. He's never participated in her life. He's never communicated with her. And he has said to Bianca's counsel, which is reflected in her counsel's declaration, that he supports Bianca's mother having custody of Bianca in this case. Still, for 3 years, Bianca's been trying to obtain two kinds of relief from the effects of Jorge's abandonment on her first of those is this custody determination, which will give her mother the legal right to make decisions on her behalf with respect to medical care, education, welfare. And the second is an order making SIJ findings, which is a predicate to Bianca being able to apply for federal humanitarian relief called SIGIS, which is aimed at children just like her who have suffered from abandonment, abuse, or neglect. The family court actually agreed in this case that awarding Bianca's mother custody of Bianca was in her best interest. And it also agreed that returning Bianca to Honduras, where her alleged father, Jorge, lives, was not in her best interest. Nevertheless, Bianca has been unable to get the custody order or SIJ findings she's asked for because both the family court and the Court of Appeal imposed this requirement that Jorge's paternity first be determined. And the reason that's so problematic is that paternity requires personal jurisdiction over the alleged father, and we don't have that here because Jorge lives in Honduras and he has absolutely no contacts with California at all. And while this is typical in one-parent SIJS cases like Bianca's, it's not confined to those types of cases. As amici Harriet Buhai and ACFLS explained in their brief, the same problems can arise in cases where the non-custodial parent lives in a different state and has no contacts with California, as opposed to a foreign country. And California actually adopted the UCCJEA to address the problem of lack of personal jurisdiction over parents and to allow courts to make custody determinations even in that scenario where they have no personal jurisdiction and the parent can't be brought in front of the court. So by requiring a parentage determination that has its own personal jurisdiction requirement, the lower court's decisions in this case effectively undermine that portion of the UCCJEA, because the court will now no longer be able to make the custody determination unless it has personal jurisdiction over Jorge. The Court of Appeal actually confronted this problem in re Marriage of Leonard, which really illustrates some of the knock-on effects of requiring personal jurisdiction. This case was pre-UCCJEA, and it involved two divorced parents repeatedly snatching their daughter back and forth from one another and flying across the country trying to get better custody orders, and then to defeat the other parent's custody order. And even in that case, pre-UCCJEA, the Court of Appeal recognized that this requirement of personal jurisdiction would just perpetuate this kind of behavior with the child as a pawn in between feuding parents. And accordingly, it ruled in that case, what would later be codified in UCCJEA, that personal jurisdiction isn't necessary to make a custody determination, and it really shouldn't be.
So I understand, as I read the trial court's decision in this case, it seemed particularly concerned not just about the custody aspect of the case, but about the SIJ findings, and I think it was particularly concerned about two elements of what the SIJ statute requires the court to determine. One is that a father, and two, that the father has abandoned the child, which the court saw as being sufficiently prejudicial, that the father is a person who should be joined as a party under our usual joinder rules. Why is that incorrect?
So it's incorrect for a couple of reasons. The first is that the focus of SIJ is really what has happened to the child. Has the child been abandoned? Has the child been abused? The SIJ statute does not impose any sanction or obligation on a parent. And so the concern with prejudicing a parent by making this finding is not as present as in a case, for example, where parental rights might be taken away in a dependency proceeding, for example, prompted by domestic violence.
But is it not a reasonable inference, counsel, that a parent who's told that an official tribunal has ruled that the parent has abandoned the child would be deeply concerned in some cases?
Absolutely. And in fact, the purpose of requiring notice to Jorge and to other parents in his situation is to alert him to the proceeding in which the SIJ findings are being sought, and to enable him to to intercede in the case and to state his objections to those findings.
And briefly, outline how, as you interpret the statutory scheme here, the proceedings would have played out if the father had said, no, I disagree, I don't think I've abandoned my child.
In that case, what would happen is, under the current rule of court 5.24, the permissive joinder analysis would likely proceed as follows. Actually, in fact, in that case, it might even be mandatory joinder, because if by denying abandonment, Jorge is asserting a claim of custody, then his joinder becomes mandatory.
What if Jorge resided in Los Angeles? Would the court have been within its discretion in concluding that Jorge should be joined as a party in order to make the finding that he abandoned Bianca?
If he had resided in Los Angeles, we wouldn't have the personal jurisdiction issues that we have in this case, but the analysis of permissive joinder would have been the same, in that the court would be required to determine if he was indispensable to make an order on any of the issues in Bianca's case, and then, or to enforce a judgment on those issues. And then the court would have to go through an analysis of 4 factors about whether, for example, his joinder would delay the case or confuse the issues. So that would not change if he were here versus out of state, as he was.
One of the curiosities, I don't know if you can help me with this, about the Court of Appeals decision in this case is that it rests largely on the permissive joinder rule and the rule of court. But the permissive joinder rule doesn't seem to address the situation, near as I can tell. It talks about when the court is within its power in joining a party, and doesn't seem to specifically address the situation in which the court can't realistically join the person as a party because that person is beyond the court's jurisdiction, which is, by contrast, an issue that is dealt with in the general joinder rule in Section 389. How do you understand the interaction between the rule of court and the general rule about indispensable parties?
So under Code of Civil Procedure 389, the question is really whether the proceeding would, if it proceeded in Jorge's absence, would somehow prejudice his rights in the case. And under permissive joinder, the question is whether he is indispensable for the court to make a decision on those issues. So I do think there's a slight difference in the court's analysis in that case as between the 2 rules. In terms of Section 389, I think the analysis is that Jorge would have to claim an interest in the subject of the action, and disposition without him would practically impair his ability to protect that interest. I think the outcome here would be the same, because nothing that's happening in the proceeding that Bianca brought actually prejudices Jorge and his ability to assert rights in the future. And so I think the court would reach the same answer under either mode of analysis. Did I answer your question?
Yeah, I guess the question is, in a situation in which we sort of start from the premise that we can't join this person because this person is beyond the jurisdiction of the court, does it make sense to begin with the rule of court and ask whether the court was within its discretion ordering joinder anyway as a permissive matter, or should we instead ask the question under Section 389, is this a party who might otherwise be necessary to be joined, but if he can't be joined, the suit can go on anyway?
I think you have to do both, actually, and I would expect that the court would need to consider whether joinder is mandatory under both Rule 5.24, and if not, then if it believed that it was appropriate under the permissive joinder rule to join Jorge. And I think that analysis under Code of Civil Procedure 389 also has to take place. The court has to consider whether there's evidence that Jorge claims an interest in the proceeding that might be, and his ability to protect that interest would be impaired. So I do think that if it had, if in the record before the court there was evidence that Jorge claimed an interest in the proceeding that might be prejudiced, it would be obligated to consider Rule 380, Code of Civil Procedure, Section 389.
Would you like to address the adequacy of the notice issue?
Yes. Sorry. So one of the issues that has been raised in this court in the respondent amicus brief was the adequacy of the notice that Jorge received, and specifically whether that notice ought to have been translated into Spanish. And it is certainly the case that the law now, and as it existed when Bianca served her alleged father, that no translation was required. Nevertheless, she did actually provide notice to her father in Spanish through 2 phone calls made by her counsel, conducted in Spanish, and attested to under oath in 2 declarations of due diligence. So even if that rule had existed, and it doesn't, Bianca would have satisfied it. So in her specific case, not only was there no legal requirement for Bianca to translate the notice made to her, but she did it anyway out of a concern that he understand the proceedings and the relief being sought.
Was the notice specific as to the relief being sought, so specific about the findings that were being sought for purposes of federal immigration status?
Yes, it was. In fact, the declaration of due diligence, the second one, there were 2. The first was with respect to a guardian ad litem proceeding. The second addressed Bianca's request for order making a custody determination and SIJ findings. Bianca's counsel, which is recounted in this declaration, explained that Bianca was seeking to be placed in her mother's custody and was seeking SIJ findings, and asked whether Jorge was in agreement with this order, and he said that he was. Those findings were also transmitted to him by personal service and mail in Bianca's actual proposed order. So they were also set forth in it. And Bianca's counsel in Spanish explained that she would be sending these to him, along with blank response forms, which happen also to be in Spanish.
And did you want to address the issue of the motive for seeking the findings?
I would. I do want to be conscious of my time for my colleague here. And
You have
save
about
a
1
little bit
minute
for
before you
rebuttal.
move into your rebuttal time. So,
Okay, terrific. Thank you. I would like to briefly address the motive point. One of the decisions the Court of Appeal made was that Bianca should not be able to obtain SIJ findings from the family court because it believed she had brought her custody proceeding largely to obtain those findings. The Court of Appeal actually inferred this from the fact that Bianca didn't appear to be having any medical or educational problems without a custody order, so it deduced that there must be some other motive. In fact, however, Bianca was represented by a guardian ad litem in this case, and the family court extensively questioned the guardian ad litem, Bianca and her mother, and concluded after considering all of that evidence that Bianca had right to the custody order, that it was in her best interest. And so there really is no basis in the record for this conclusion that there was something untoward about Bianca's motives. As far as a basis in law, the legislature, in response to the Court of Appeals decision, amended Section 155 of the Code of Civil Procedure, which says unequivocally that courts cannot rely on or inquire into or refer to a child's motive for seeking SIJ relief when making the findings necessary to apply for that relief.
Can I ask you about the premise of the argument, which rests on a passage in the USCIS policy manual about the administration of this particular scheme, how the applications for SIJ status will be processed? Do you have a view on whether or not that policy manual has the force of law?
The policy manual does not have the force of law. However, it is informative about how the federal government views the interpretation of the federal SIJ statute and what it expects from family courts. And in this case, the current USCIS policy manual explains that there is nothing wrong with a child having some motive for obtaining immigration relief when that child asks for the SIJ findings in the family court. So from the federal perspective, that is how SIJ is currently being interpreted. If there are no other questions, I'll reserve the rest of my time. Thank you.
Good morning, and may it please the court. I'd like to make 3 main points on the joinder issue. First, the existing laws and rules adequately protect the interests of alleged fathers like parents and like Jorge in this type of proceeding without a requirement for their joinder. Second, under the circumstances here, including the fact that Jorge is out of the state and has never asserted a claim of custody or visitation with respect to Bianca, it is an abuse of discretion to require his joinder, and I'd like to respond to Justice Kruger's specific questions on that point. And third, more generally, although the Court of Appeals rule was well-intentioned, it really does create the possibility of some perverse results and incentives going forward. If I might just start briefly on existing law, the Family Code is clear that in this type of proceeding, an alleged father has to receive notice and an opportunity to be heard with respect to the parentage action and the request for a custody determination. And as of 2016, the rules of court are now clear that the alleged father also has to receive notice of the request for SIJ findings, including the underlying allegations, and an opportunity to respond. And if that person decides to assert a claim of custody or visitation, the rules also require that he be joined to the proceeding. So there's no need to superimpose an additional joinder requirement on top of existing law beyond what the rules and the Family Code already require. Now, as to abuse of discretion, the family courts do have the ability to order permissive joinder in appropriate circumstances under Rule 5.24E2, but that discretion is not limitless. And the rule is clear that it needs to be based on a finding that the person to be joined is necessary or indispensable to the resolution of an issue before the court, and that it's appropriate to resolve that issue. Now here, Jorge's presence is not necessary or indispensable to the issues that Bianca asked the family court to resolve.
And briefly, necessary or indispensable, do you take those to be different?
I think that is the way that the rule contemplates it, Your Honor. And what it specifically says is indispensable for the court to make an order about that issue or necessary to the enforcement of any judgment rendered on that issue. As we said out in our brief, as to the 3 issues that Bianca asked the family court to rule on, the maternity of Gladys, a sole custody award to Gladys, and the SIJ findings, Jorge is not necessary or indispensable. Now, I think the Court of Appeal reasoned that permissive joinder was appropriate here because it was necessary to resolve the paternity issue in these proceedings. And that, I think, gets to the question that Your Honor asked. If we're looking at 5.24E2 as opposed to the Code of Civil Procedure, I think that the factors laid out in E2 do contemplate that there needs to be some consideration by the family court as to the practical consequences of joinder, and that there can be an abuse of discretion if those circumstances would, for example, complicate, delay, or interfere with the effective disposition of the proceeding, which is in Category D of 5.24E2. So the rules are specifically calling for the courts to think about, similar to what you might do under CCP 389, what happens if I join this person? Now here, you're dealing with an alleged father who is not only out of the state but out of the country, over whom the family court does not have personal jurisdiction and who's shown absolutely no interest in participating in these proceedings. Under those circumstances, in our view, it is an abuse of discretion to require permissive joinder. I think that the analysis could potentially be different if you're dealing with a father in Los Angeles County, where there is, personal jurisdiction over the individual, and the analysis under E2 would play out differently. It might not complicate or frustrate or delay the proceedings in the same way. On Your Honor's question about whether we're looking at 5.24E2 or the Code of Civil Procedure, I've wondered about that myself. I think subsection A of 5.24 says that we apply this rule as well as the Code of Civil Procedure, except insofar as this rule departs from the Code of Civil Procedure. 5.24 is the more specific provision. I don't think that there's any provision I'm aware of in the Code of Civil Procedure that would render joinder here appropriate. And as to section 389, my read is that that wouldn't apply here, because what you need to have before you have joinder under 389 is a conclusion that either complete relief can't be accorded in the absence of the individual to be joined. We don't think that that applies here. Or second, that he claims an interest and that the disposition of the proceedings may implicate that interest. And here, Jorge has not claimed an interest. So the analysis would be different if he came to the court and indicated that he is claiming custody or visitation rights, but he has so far not done that. If I could just make a point about what I think the practical consequences are of the Court of Appeals rule here. What the rule effectively amounts to is a barrier to a young woman like Bianca obtaining SIJ relief unless her absent alleged father voluntarily and affirmatively participates in the proceeding. And that means that a young woman like Bianca, who's happily living with her mother and who's abiding by the laws, can't get the SIJ predicate order she needs to go to the federal government. But if you imagine a similar woman who perhaps violates the laws and ends up in delinquency court, or is abused by her mother and ends up in dependency proceedings, that person could presumably get a predicate order and seek SIJ relief. Another problem is that the Court of Appeal, as I read its opinion, suggested that Bianca's case can't move forward, but perhaps it would be able to move forward if the whereabouts of the alleged father were not known. Now here we have a young woman who has come into court and truthfully told the court, I know where my alleged father is. I've done everything that's required under the code and the rules to provide him with notice. And the result is her proceeding can't move forward. But if someone else similarly situated comes in and says, I'm sorry, I have no idea where my alleged father is, I think the Court of Appeal is suggesting that that case could move forward. I don't think that there's any reason under the law or the rules of court why we have to have those disparities. And I think that they are not consistent with the thrust of the federal SIJ statute or California's Code of Civil Procedure, Section 155.
We've received notice that your friend on the other side is going to argue that documents translated into Spanish are required. Your response?
I think that that relates to two issues, one legal and one policy. As a legal matter, they're not required. The notice here was sufficient, and none of the existing rules of court or the family code require these documents to be translated into Spanish. As a policy matter,
just talk louder.
I have no idea what that noise signifies, but just yell at us, you won't be the first.
I think as a policy matter, the question of whether there should be additional requirements is an important set of complex. Obviously, there can be some benefit to additional translation in terms of access to justice and fairness, but it can impose substantial costs and burdens on a party. And when you have a young woman like Bianca who maybe has more limited resources, it could, as a practical matter, make it more difficult for her to seek relief than she would otherwise be entitled to. So I think that these are issues that can and should be continued to be studied by the legal counsel and the legislature, but the bottom line is that they don't provide a basis for prohibiting this action to go forward in these proceedings.
stand down for a moment. We could make you go forward, but now you're being circled by all men.
I appreciate it.
Breathe. Thank you.
I'm not sure where I'm left with my time, but there was one question.
You're about there, but go ahead. Under adverse circumstances.
If I could respond to one question from Justice Kruger and then just finish up. There's a question about whether it's appropriate in this type of proceeding to make SIJ findings without first establishing paternity. I think that really boils down to a question about the meaning of Section 155 of the Code of Civil Procedure. We think under these circumstances, the term parent in that statute should be construed to include alleged fathers in addition to presumed and biological parents. The legislature did not expressly require that these findings be made about a presumed parent or a biological parent. It's talking about findings of abandonment, and as a practical matter, when you have abandonment, that can make it difficult or impossible for a minor to establish presumed or biological parent status. And it is expressly directing that these findings can and should be made in divisions of the Superior Court that don't typically make paternity determinations and that host proceedings as to which parents are not parties, so they wouldn't be able to make a paternity determination. And I think that brings me to my final point here. Just the stakes here, I think, are serious. We have a young woman who's immigrated to this country after a very difficult experience in Honduras. On the face of things, it appears that she is eligible for a form of federal immigration relief that could lead to lawful permanent residence in the United States. And she's coming to a court of this state seeking, among other things, a predicate order that will allow her to seek that relief. I think that's exactly the type of case that Section 155 had in mind. And although the family courts should, of course, apply the law faithfully to the evidence before them, we shouldn't impose additional requirements for these young people beyond what the law already requires.
Very well, thank you.
Thank you very much.
Good morning, Your Honors. Court-appointed amicus Rachel Lerman. I guess I would like to start by addressing the due process issues and whether there was adequate notice. Of course, the lower courts were very concerned with whether Jorge received adequate notice under the circumstances, and I believe the Court of Appeals said that he had not received notice that she was seeking an abandonment finding. And when I wrote my brief, I couldn't find where in the record that had been addressed, and it seemed to me that he probably should be on notice that she was seeking an abandonment finding. After the reply brief was filed, I was able to see that if you look at AE 112 and AE 119, he was in fact put on notice that she was seeking an abandonment finding. So that doesn't seem to be a problem after all. In terms of the translation issue, I didn't mean to imply that I was going to say translation is required. The Court of Appeal raised the issue without taking it any further, and it wasn't briefed below. It seems to me a good question, but as my friends have explained, Jorge does seem to have received telephonic notice in Spanish, and there is no law presently requiring translation of documents in these circumstances. There is a requirement in dependency proceedings where the social workers are required to give notice that is translated, but as of yet, not that the legislature nor the Judicial Council has ruled that it's required in proceedings like this. And of course, there are arguments on both sides for whether it should be required, but I don't think that the question needs to be reached here because it appears that he received adequate notice under the circumstances.
So on the joinder issue, do you agree or disagree with your friend's view concerning whether we need to look at the question through the lens of Rule of Court 5.24e, Section 389 of the Code of Civil Procedure, or both?
I focused on the rule of court. I think that's what the courts below focused on. And I agree that you would reach the same result under either rule. 524 does say that if a person in Jorge's position wanted to be a part of the proceeding, it's mandatory that the court shall allow him to be joined. So,
right. I guess the focus of the Court of Appeals opinion was more on the permissive joinder provision,
Correct.
which, again, just to repeat myself, it seems a little bit peculiar to talk about a court's discretion to join a party as a permissive matter if we know from the outset that the person cannot be joined because they're beyond the court's personal jurisdiction.
Well, I agree with you, and I also agree that under the necessary and indispensable rule that my friends have discussed, I cannot see how he would be necessary or indispensable in these circumstances. Both of the statutes, the UPA and the UCCJEA, permit these custody determinations to be made without personal jurisdiction over the absent parent, as long as notice and opportunity to be heard is given. And while this court hasn't actually ruled on the jurisdictional issue, it seems to me that the Marriage of Leonard decision has a good and intelligent discussion of that, and I would agree and urge the court to consider adopting that rule, especially in light of the statutes, which provide that you don't need to have personal jurisdiction over the missing parent. And I'd also point out that the UCCJEA is not just concerned with custody alone. It was concerned also with parental kidnapping, and you can read that if you read the purpose of the statute. It was concerned with issues of abandonment and abuse. So all of these things were taken into account by the drafters and by the legislature when it enacted the UCCJEA. They understood that these kinds of questions might come up, and yet personal jurisdiction is not required, nor is the presence of the absent party required.
But what about the SIJ findings and the trial court's concern about prejudice to a parent, potential prejudice from having a finding entered by a court of law that that person is a parent for purposes of the SIJ statute and has abandoned his or her child?
Well, I understand that concern, and that's why the notice issue is so important. The courts believed he wasn't even on notice that there was going to be an abandonment finding. And if that were the case, I think that would be a problem, or it would be certainly a strong potential problem, since due process is kind of a balancing procedure, and you would have to weigh the child's rights against the absent father's. And we know that since he's not a presumed father, he's only an alleged father, his rights are limited, really, to notice and opportunity. But would he have if he doesn't have notice of abandonment, it seems to me that would be, could be problematic. And here he does have notice of that, and he did not elect to come forward or write a letter to the court or do anything to object to that finding being made. So I think in this particular case, that issue is covered. It's true that the statutes right now don't tell us in this peculiar set of circumstances whether he needs to be on notice of the abandonment finding. And that could be a question for the legislature, could be a question for your honors. But I understand the lower court's concern with that to make sure that he knows there's going to be an abandonment finding so that he has informed consent when he says, I'm not going to get involved in this. Another issue is that because there would be no personal jurisdiction over him, I don't think there would be a res judicata effect of this decision, so that if he wanted to come forward in the future and try to challenge the finding, he would be able to do that.
Right. Although presumably that's true in any case in which, or many cases in which a party should be joined and is found to be beyond the court's jurisdiction, and if it decides that the case can't go forward without them, then that's one thing. If the case does go forward without them, then presumably they can't be bound.
Right. And in child custody cases, they deal with changed circumstances all of the time. So, the orders can be modified if changed circumstances arise, and there can be another proceeding with respect to that. I don't think that's likely in this case, but I think there are many ways in which the system avoids prejudice to the alleged father if he's given proper notice and opportunity to be heard, and if he wishes to come forward and show that he's a presumed father. Only if he can show he's a presumed father would he have additional rights. And there's no evidence in this case that he would be able to do that, and certainly he hasn't tried to do that.
Let me ask you a broader question, counsel. So we have very much before us these particular facts, but in thinking about how a fairly complex statutory scheme that is interlocking with federal law operates, part of what the backdrop is thinking about fact patterns that are not so clear-cut, that may raise more troubling questions about exactly what counts as notice and, the translation issue. So what would you have us bear in mind in thinking about how this statutory scheme operates to be mindful of those other situations that might raise perhaps even more pronounced due process type problems?
Well, I think, again, it comes down to the adequacy of notice. I think we need to be reasonably certain that the alleged father, the missing parent, is on notice of the findings that are being sought. And he was put on notice of those, albeit not in Spanish, although we don't know perhaps what was discussed on the phone in Spanish because we don't have a complete transcript of that conversation. But he certainly had opportunities to ask questions, and he didn't seem to have any problem with the mother acquiring custody over the child. I would think that in a kidnapping case, if a missing parent is put on notice that this sort of proceeding is about to take place, he would immediately send off a letter to the court and say, wait, these people aren't telling you the truth. You need to hear my side. And I think that in those circumstances, a court would have to hear that side.
Thank you.
Are there any further questions? I think joinder was adequately discussed by my friends.
I think the remaining question has to do with the motive analysis, whether motive for seeking the findings ought to play any role in the court's evaluation of the adequacy of the suit.
I mean, whether the proceeding was bona fide. I think that Section 155, as amended, helps us there, and I also think that the federal government's the UCSIS isn't binding, but it makes very clear that, and from the point of view of the federal administration, this is not the issue they wanted the state courts to address. They were not asking the state courts to consider this person's eligibility for citizenship. They just wanted a state setting in which to make these particular findings that they thought it would be more appropriate for the state to make before allowing the child to move forward and get the SIJ findings. So I'm not sure that she would have had any options other than this kind of a custody situation. She couldn't have gone to the probate court. She couldn't have brought a dependency sort of an action. It was really the only option she had under California law, and I think under most states' law, is to seek the kind of custody order she did. So I think that question is pretty clearly answered by the legislature and the federal government. Are there any other questions? Then I'll
Thank you.
step down.
You have 4 minutes.
Thank you. I really just want to make two quick clarifications. One is that the current rule of court 5.130, which was passed after Bianca's petition was granted, does require a form notice of SIJ findings to be served on alleged biological and presumed parents. That wasn't the case at the time Bianca made her request, but nevertheless she served her request for order on Jorge anyway. And then I just wanted to circle back to the motive point and whether the proceeding is bona fide. I think one really important thing to remember is that the federal law the Court of Appeal was referring to, which was superseded in one case and with respect to the proposed rule never went into effect, nevertheless defined bona fide to mean the child was primarily seeking relief from abandonment, abuse, or neglect, and not primarily seeking an immigration benefit. And that's very different from what the Court of Appeal, how the Court of Appeal defined bona fide in the case below, which was that the child was not primarily motivated in the custody action by obtaining SIJ findings. There's no question in this case that Bianca is seeking relief from abandonment. The family court made the determination that she should be placed in her mother's custody and should not be returned to Honduras. So if the federal definition of bona fide were something the family court could refer to, Bianca would satisfy that.
Do you understand the federal guidance, such as it is, about what counts as a bona fide proceeding, as requiring us to draw a sort of strict dichotomy between motive to seek relief from abandonment or neglect and motive to seek an immigration benefit? I would imagine that there'd be many circumstances in which the two might be intertwined. A child's ability to seek relief from abandonment might have a lot to do with whether or not the child has a continuing ability to remain with a caregiver in the United States.
So if I understand the question, it is, I think there's two parts to the answer. One is, I think the federal scheme does not contemplate the state courts having any part in inquiring into the child's motives. The Section 155 of Code of Civil Procedure sets forth the extent of the state court's role in that there should be no inquiry into the motives. My point is that even if courts were authorized to engage in that analysis based on what the federal government does to determine if a request for SIJS is bona fide, Bianca would satisfy that, because there is no question on this record that she's primarily seeking relief from abandonment, abuse, or neglect. If there are no other questions, I'll be happy to submit. Thank you.
Very well. Thank you, counsel. The matter will stand submitted. Thank you, Justice McCarthy. Thank you. In the matter of Irma Ramirez versus the City of Gardena, the court is joined this morning for this case by the Honorable Luis Lavin, Associate Justice from the 2nd District.
Good morning, Your Honors. My name is Abdullah Anabi. I represent the plaintiff and appellant in this case, Ms. Irma Ramirez, and the estate of Mark Gamar. May it please the court. The issue before the court is the discretionary immunity under 1704.7 of the Vehicle Code available only if all officers of a given police agency certify in writing that they have read, received, and understood the pursuit policy of that department. In this case, also we have a sub-issue of what is meant by the word all with regard to 1704.7. Does effectively the word all mean all? In this case, according to the plain reading...
That's quite a question.
Pardon me?
That's quite a question. Does all really mean all?
Does all mean all? Absolutely. In this case, with regard to the plain language of the statute, with regard to the legislative intent and purpose of the statute and the legislative history, and with regard to the publications of the Commission on Post, the answer to the question, both the primary and secondary issue, is yes. It's clearly yes. 1704.7 of the Vehicle Code, as we know it today, was actually developed out of a case that came out in 2002 called Wynn versus City of Westminster. In that case, we had a pursuit that ended in the death of an individual In that case, the affirmative defense of the immunity under, at the time, 17004.7 was asserted. At the time, the statute only required that they adopt a pursuit policy. That was all that was required at the time in 2002. The court in Wynn, the Court of Appeals, decided ultimately to uphold summary judgment, stating that at the time the statute, all it required was adoption of a pursuit policy. However, the court articulated in its opinion that it was disturbed by this result, given that a given police department may adopt a policy, but that no officer may ever learn it, no officer may ever understand it, and no officer may ever read it. So therefore, after the Wynn decision, the legislature took up to amend 17004.7. And what the legislature did is they met collectively with police and citizen associations and groups, and they concluded that they wanted to add an additional clause to 17004, which was promulgation. The idea behind promulgation, both by the legislature and Post, was that the department must not only adopt a policy that is consistent with the guidelines presented by Post, but it must promulgate these pursuit policies for the safety not just of the general public, but for the safety of officers. Promulgation then became, though adoption was never defined by the statute, promulgation certainly was. And under the statute, section B2 to be exact, promulgation consists of all officers of the department must sign and certify in writing that they have read, received, and understood the policy.
So if one officer has not done so at the time of the pursuit accident, the result under your rule is what?
They would not be able to obtain the immunity.
So you have 1,000 police officers here in Los Angeles. Certification is not signed by one of them until 10 o'clock.
Yes, Your Honor.
And accident occurs at 9:30?
Well, Your Honor, with regard to the timing of when officers sign the various certifications.
But under your rule,
yes,
the result is what?
The immunity would not be obtained. And that's not my rule, Your Honor. That's the plain language.
You really think that's what the legislature meant when they set up a certification procedure and an annual training procedure, that this was a timeline that every municipality, every police agency has to comply with 100%, or there is no immunity?
Yes, that is the rule. And that's not established by me. It's established by the legislature. But more importantly, it's established by Post. Post is the one who determined this, that it must be in writing. It must be all officers.
I'm just trying to wrap my mind around Justice Chin's hypothetical, and I don't, you may have other arguments you want to make, but I want to just pursue his hypothetical and ask you, why isn't the right, even if I accept your premise, why isn't the right way to think about it that if the right number of officers sign these certifications on the day of the accident, that's okay?
On the day of the accident?
Yeah, on the day of the accident.
Well, one of the requirements also for the statute is that it must be signed annually, meaning the year prior to the year of the accident.
So the last officer that would, if not signed under your reading of the statute, trigger a loss of immunity, signs it on the day of the accident, but not before the accident occurs.
Well, it must be signed annually, meaning the previous year. If an accident occurs, in our case, the accident occurred in 2015. If an officer signed it in 2015, it wouldn't be annual. He would have to sign it within the year of 2014. And given that scenario, they would have actually potentially more than a year to be able to come to within compliance.
You can see what I mean, just to further clarify. My understanding of Justice Chin's hypothetical is if the last moment at which the officer had to sign the policy in order to comply with the annual certification requirement were on the day of, but not necessarily before. Like, in other words, I want to understand how you're deriving this precise timing rule about when this stuff all has to be completed by.
Well, it all has to be completed within the year prior, meaning it is not to be signed within the year of the accident. It must be signed the year prior. And if it is signed within the year prior, and it is all officers, then they do have the immunity. If one officer doesn't sign it, according to the plain language of the statute, the word is all. All is an absolute. There is no less than. There is no substantial compliance. Yes, sir.
What if the non-signing officer was hired on the day of the accident, and so is, sort of by the time the accident occurs, the person has just gotten the tour of the building and nothing more?
Again, Your Honor.
In other words, is there some sort of reasonable period that you would give for?
The reasonable period is they have a year to obtain it.
But in my hypothetical, there is no year for that officer. That officer came on board the day the accident occurred.
Well, then he wasn't employed in the prior year, and the department has nothing to worry about. If officers are hired in the year in which the accident occurred, they're not subject to signing anything. They're the officers that sort of are to be scrutinized and whether they actually certified and signed are those officers that were employed in the year prior. The legislature and Post established that it must be annually signed.
But that raises the next question, again, to pursue this hypothetical. So if the year expired at precisely the day the accident occurs, and in fact, if the officer were hired at 9 a.m., I assume that under your reading of the statute, the certification would have to be hired by 9 a.m. within a year, or is there a grace period?
No, it's not so much a grace period, Your Honor. In other words, let's assume that in our case, 2015, an officer was hired in 2015 and an accident occurs within 2015. The only certifications you would be looking to are those within the entire year of 2014. Meaning if an officer signed it in 2014 and he signed it perhaps a few months outside of the 1 year from the date of the accident, it's still within compliance, so long as it's within the calendar year before. If someone is hired the year of the accident, it's immaterial for purposes of the immunity.
And I imagine that under your reading of the statute, given the answer you've just given, it's completely immaterial if the failure to obtain a signature from all the officers necessary within the proper period is inadvertent, clerical error, just a mistake, doesn't matter. This is like a strict liability statute.
Well, first of all, it's not strict liability, Your Honor. It's a matter of whether they obtain an immunity or not.
Right, but what I mean is they are strictly subject to the loss of immunity if the failure to comply is completely inadvertent, not intended, just a slip of a paper that gets lost.
Again, Your Honor, I go back to the plain language of the statute. All means all.
So
Pardon me.
No, please.
Yeah. If all the officers signed annually, meaning the previous year, the previous calendar year, not necessarily a year from the date of the accident, but the year prior, then they're covered. They obtain the immunity. If they do not, then they do not get the immunity. And again, that's not based on what my interpretation is. It's based upon what the language of the statute is. It's based upon what Post requires as well. Post, which governs the way in which officers are to be trained and the manner in which they are to operate in terms of their administrative processes, they're the ones who say this, not me. And
so can I direct your attention, since we've talked a lot about the plain language of the statute, can I direct your attention to the language of the statute?
Absolutely.
So the provision that we're talking about begins by saying that the immunity applies when the public agency promulgates a written policy, and then it goes on in the next paragraph to say that promulgation of the written policy shall include a requirement that all peace officers of the public agency certify in writing.
Yes.
So the requirement is promulgation, and promulgation is in turn defined to include a requirement that there be a return of a certification by all of the officers. Why isn't it feasible or reasonable to read this language to require not necessarily that all of the written certifications be returned, but that the policy promulgated by the agency include this requirement?
Okay. If I understand Your Honor's question, the question is, why isn't it just the requirement to do so?
Right.
Again, I go back to the issues established by Post pursuant to Post is the one ultimately who makes the decisions as to what it is promulgation consists of. Post was given that authority under 13519.8 of the Penal Code. Under the Penal Code, Post is the one to make determinations about adoption, about what these pursuit policies are to consist of, and more importantly, what promulgation is to consist of. And under Post's interpretation, based upon their publications, promulgation consists of all officers receiving the policy and signing what Post deems as the ideal, which is to sign a form indicating that they have received, read, and understood the policy.
So you're not arguing, so your argument is, that sounds like an argument based less on the plain meaning of the statute and more on deference to an expert commission. Is that a fair summary?
It's not inconsistent, and I'll explain why. That 13519.8 of the Penal Code is the statute which defines who shall make these determinations in terms of the guidelines for establishing promulgation. That very statute actually reads, the title of the chapter, it reads Field Service and Standards for Recruitment and Training. Training in this issue relates to the pursuit policy. The statute itself specifies that Post is the one to establish the guidelines for promulgation. Post has determined that promulgation must require all officers, all of them, to certify in writing, and furthermore, that writing, according to Post, must be retained. It must be retained by the department for the very purpose of issues like today. They have to demonstrate that they've met the requirement, that all officers did it in the year prior. In the year prior, they have potentially more than a year to obtain all the officers who were active within that year to come within compliance. We are not talking about an unreasonable situation where somebody's hired the month before or the month after an incident and therefore they don't obtain the immunity. The other thing we must consider too is that this immunity is absolutely discretionary. No department has to comply with this. They don't have to at all. The legislature made the determination, actually, Your Honor brings up a good clause of the statute. The following sentence reads that the failure to meet this immunity does not permit the other party, plaintiff such as my client, to use that to establish liability. Something the Court of Appeals, frankly, looked at and made the determination that somehow not obtaining the immunity and that not obtaining the immunity was kin to establishing liability.
But if I could pursue Justice Kruger's question, it sounds like, leaving aside your argument about Post, which I understand, do you still insist that the statutory language precludes even a grace period or a recognition that when an agency makes a very substantial effort to comply, believes it to itself to be in compliance, and in fact, because of some clerical error, is not in compliance, the statute still forces a loss of immunity?
I'll go back. The requirement isn't the issue. The requirement, I mean, it is an issue, but the issue that must take place is that all officers must sign. With regard to whether the department makes a clerical error, the statute actually is silent to that. It doesn't have substantial compliance anywhere in the statute. The statute only reads all. It doesn't say some, it doesn't say most, it doesn't say except if one forgets. It says all. And all is not the type of word that really lacks a certain level of ambiguity. All is like shall or must or cannot. There is not much ambiguity in the word all. And it's, again, it's not just limited to the plain language of the statute. Even if we look to the legislative intent and the legislative history, the reason the legislature imposed this type of standard is because the immunity should be given with some reservation. When officers commit a pursuit where someone is killed or injured as a result, the statute gives them absolute immunity, regardless of how egregious, how negligent, or how reckless the officer was. It makes no difference.
Mr. Nabi, you've moved into your rebuttal time.
Thank you, Your Honor. I will conclude. I reserve time, of course. Thank you.
Thank you.
Good morning. I'm Liddell Hewlett-Muhlstein with the law firm of Manning & Cass, Elrod, Ramirez, and Trester, representing respondent, the city of Gardena. Much of my opening actually parroted exactly what counsel said, that in this case, the court has granted review of the narrow question.
So does all not mean all?
All does mean all, but what all pertains to is that the requirement that the agency must have, and the agency must require that all of its officers certify. All does not pertain to the number of officers who must actually certify. So what is required is agency compliance with the statute, which requires that they have a requirement that all of their officers certify.
And counsel, what does it mean to have a requirement? Is that just, we have a requirement, it's printed on this piece of paper, or is something more required?
No, absolutely not. In this case, what the legislature was concerned about making sure there was a real implementation of those policies, and so it enacted twin requirements, the promulgation requirement and the training requirement. And when you take those two together, they're intertwined. You're not going to be able to train on a policy if the officers don't know what the policy is.
So you need certification.
Pardon?
You need certification, and you need annual training.
Correct. And I would like to point out that.
Now, what if something doesn't occur right before the accident in the hypothetical that I gave your friend on the other side?
What I understand from his position is, and I don't know where he incorporates the 1 year limitation. I don't see it in the policy, and
the statute doesn't say anything about that.
Training has to be annual.
Okay.
But there's nothing in the statute that talks about a time frame for certification.
So what if the training program doesn't occur until after the accident caused by a particular pursuit?
I think that the legislature intends for that to be okay. They gave an annual requirement for training. So the agency must provide annual training. And that training, and in this case, the agency provided ample training. They provided training 3 times within 6 months prior to this.
But in some ways, my question carries over to the training context. I understand your point about training and the relationship to the time frame and all that. Right. But if the agency says we have a policy that training should be annual, we make training available annually, but it turns out that as a practical matter, 20% of the officers are taking advantage of this training. Does that implicate the statutory requirement in some way? Does that affect this, whether the statute allows the agency to be seen as being in compliance?
I think that the parameters of the training requirement, how much is enough, or the parameters of certification, how many certifications you have to have, could, in some circumstances, be an issue for the court to determine. Was there certification here? Was there promulgation? Was there training? In this case, the court found that there was training, and in fact, plaintiff does not even challenge and has never challenged the adequacy of the city's training procedures. So in an extreme situation, it could be an issue for the court to determine, but in this case, the court has made those determinations. I think it does have to be a bona fide training program, but we have the city has mandatory training.
What if more than 50% of the officers never fill out a certification or never go to training? Could the city lose its immunity? And would that be a triable issue in every case as to whether there's substantial compliance?
I think it would. I think we will develop standards over time as different these cases come before the court in different factual situations. For today, the issue is 100% enough or is 100% not, and a sort of sub-ruling, is what the city did enough? And I think the answer to that clearly is yes, what the city did was enough.
But that is premised on the idea that there is a standard already kind of there, built into the statute, no? I mean, we might articulate what it is and its parameters over time, assuming the court were to agree with you, but just to follow up on Justice Levin's question, What is the basis for concluding that the agency lived up to its responsibility in the statute here? In other words, if we need more than simply the agency's bare assertion that there does exist a policy, it's written down on this piece of paper, and here it is.
Well, in this case, the agency has mandatory training for its officers. When they come to the training, they read the policy out loud. It's distributed to them, and they read it out loud to each other. Then they have a discussion of real-life application of the policy. At the conclusion of the training, they're required to sign a training roster to indicate that they received, read, and understand the policy. In addition, we had evidence that the city provided this training for the 6 years previous. We have roster documentation that 81 of 92 of the total officers employed at the time of the incident had signed the...
What is your response to opposing counsel that is not all?
Again, my response is that the requirement that the legislature reached in reaching a balance, it's very clear from the legislative history that they were trying to find a balance between public safety and effective policing, being able to make a pursuit, being able to apprehend suspects. And when they reached that balance consisted of this intertwined requirement of promulgation and training. And what is required is that it's clear, because this is a statute that provides immunity for an agency. So it's clear that they are looking at what does the agency need to do to earn that immunity. So the requirement is that the agency comply with the statute and impose a requirement on its officers. The fact that there is not an additional requirement that the agency chase down every officer and ensure 100% compliance with its requirement. We could look for a moment at the statute itself. I want to look at the infamous last sentence of sub B2. I think it's very important that the legislature added this caveat sentence, and we think about what was the point of this caveat sentence. The legislature seemed to be answering the question, what if one person, one officer, an individual officer, doesn't sign the certification? And what the legislature said is, the failure of an individual officer to sign a certification shall not be used to impose liability on an individual officer or a public entity. So we have the legislature addressing the situation of an individual officer who doesn't sign, but not saying the result of that is loss of immunity. So the statute itself, it's implicit in the statute that 100% officer certification is not the standard that the legislature intended to impose.
But if your reading of the statute is correct, why is that sentence necessary? What work is it doing?
It poses a question as to what the purpose of that statute, of that sentence is. In the respondent's brief, we've set out a couple of possible purposes. Foreclosing a plaintiff's claim that violation of the policy constituted negligence per se, or suggesting that somehow the statute provides a statutory basis for governmental liability under Government Code Section 815. But the sentence seems to be redundant for those purposes because those issues have already been dealt with. So the only remaining possible purpose seems to be to clarify the fact that 100% certification is not required. Even though the word all is in there, it means all pertains to what the scope of your requirement, not to actual compliance by 100% of your officers by the date of an incident, which no one can know when that is. And the court, by its questioning, seems well aware of the excellent amicus briefing talking about the practicalities of real policing and how imposing this, the appellant's interpretation of this statute would impose virtually impossible burdens on the agencies. I think we've touched on legislative history, but there are 2 points, I think, to be made. And one is that the legislature elected not to adopt most of the restrictions on immunity that the Nguyen court wanted. Instead, they said, and the Senate Committee on the Judiciary said, we are going to impose a balanced, more moderate approach, a modest limitation on immunity. So the legislature was striking a balance between this nominal policy adoption, which was the state of the law at the time of Nguyen, and a requirement that officers involved actually have to comply with the policy in order to obtain immunity. And so they selected requirements for immunity that reached the correct balance between safety and the law enforcement's ability to enforce the law. And that balance was this twin entwined requirement of annual training and promulgation. And the fact that there is the training aspect of it ensures that promulgation is not going to be an empty requirement. It's not going to be, okay, everybody certify, but we're never going to tell you what the policy is or train you on it. So that ensures that there is an actual implementation of the policy, that officers are trained, they do know what it is, they do understand it. So I think the legislature makes that clear, that that was the balance they were attempting to strike. And then the second thing that's clear from legislative history is that that the legislature was focused on agency conduct. They make it very clear that they are rejecting, they in fact did reject proposed bills that based immunity on the conduct of the officers. They rejected a bill that said the officers must comply with the policy or no immunity. They rejected a bill that said the officers must act in good faith or not be grossly negligent or no immunity.
So is there any degree of compliance that is required to obtain immunity?
Okay, compliance with, we're talking about the promulgation requirement or training?
Well, these two things are intertwined.
Yes, they are.
The agency, of course, has their duties and the officers have their duties.
Mm-hmm.
But somewhere in there should be a relationship, should there not? Or is it just that the agency promulgates a policy that includes a requirement, but then there is no follow-up? Is there any follow-up required?
I think the follow-up is implicit in the training. They don't say you must obtain 15 out of 30 certifications. There's no requirement like that in the statute, but it couples the promulgation requirement with the training requirement, and you're required to provide annual training to your officers.
But you're not required to keep track of how many people attend or how many people complete the training, or I'm just sort of wondering on the ground what is, the purpose, of course, is to make sure people are adequately trained. So
right.
To follow through on that, what is the agency's obligation?
Well, I think that it's important to remember that the legislature imposed some faith in the good faith of agencies. Police enforcement agencies do not want persons injured as a result of pursuit accidents. So there is an implicit degree of trust in the agency that they won't have an empty policy. On the other hand, there is some degree of teeth by requiring the training. So I think you put those two things together and you have a realistic basis for the agency doing what it's supposed to do, just as the city Gardena did in this case.
And I gather that in putting this answer together, your answer to the previous question about this, that it's rather pivotal in your argument that 82 out of 91, am I getting this right, of the officers participated in the training?
81 out of 92.
Oh, close enough. Well, one makes a difference. But to pursue Justice Liu's question, that is significant, it sounds like, in your argument. You'd think this would be a different case if it were 50-50, maybe, or less than that?
Well, again, I think it's tempting to try to put a specific number on what's adequate, but there are so many scenarios. There are 10,000
Would it make a difference if one of the you have a difference between 81 and 96, so from 81 to 96, does it make a difference that the pursuing officer was one of those in the 81 to 96 category that did not?
Under the statute, it doesn't, but certainly from an emotional point of view and from a kind of gut level point of view, it certainly does seem to make a tremendous amount of difference that those were actually.
But we don't have that in this case.
We do. Every officer who was involved in this case.
We do not have someone between the 81 and the 96.
Correct. That's correct. Yes.
And does it make a difference, again, pursuing this line of thinking to see your sense of the parameters of the statute? Does it make a difference if the agency has good reason to believe that its training is not working, and even if 100% of the officers are participating in the training, they check a box, they get half an hour of this or an hour, and plenty of accidents and collateral damage occurs on these chases? Does the agency have any responsibility under the statute to do something about the training and improve it?
I don't think so under the statute. The statute says what the training what the subjects must be trained upon, and they have met that. They have trained upon those subjects. But certainly from an agency point of view, they're going to want to improve their training. They're going to want to do a better job.
Because why?
Because they don't want people injured. They don't want lawsuits. They don't want their officers experiencing the trauma of having someone involved or injured in an accident they were involved in.
Perhaps. I mean, I'm not denying that those motivations matter, but organizations have a great deal of inertia and sometimes change very slowly, if they ever do.
Well, that's the point of change is another point that actually bears thinking about, is that if an agency wants to upgrade and improve their policies, that creates a very difficult situation, because they lose immunity, at least under Morgan. Morgan said that the certification requirement has to pertain to the current policy, so they will lose their immunity until they get the new policy in place and get everybody trained on the new policy. And I forgot when I got up here to note the time, so I apologize, and I don't know where I am.
You have 5 minutes.
Okay, great. Well, then I will just...
So can I just follow up for a second?
Yes,
So your
yes.
view is obviously that 100% compliance is not required for a
Correct.
municipality to be immune, but something less than that might result in the municipality losing immunity. Is that your position? And that we just don't need to decide what that percentage or what language we're supposed to be using, substantial compliance or good faith compliance? I'm trying to figure out what your point was on that.
Right. Well, for today, the issue that the court agreed to determine was, is it 100% or is it not 100%? So that's the tight issue for today. We hope that the court will also go beyond that and say what the city did in this case is enough. And that's the beginning of a standard, that the city did these things and that's enough. And then at some point, it's very difficult to put a specific number based on one case. There are going to be defendants that are going to come in here that have 10,000 officers, and what percentage is appropriate is going to make a difference. Or perhaps the timing, was it the day before, or all those kinds of things. But for today, 100% is not required, and what the officer did is sufficient. That's what we would like you to rule. Thank you. Let me find my... Let me just read this one sentence from Morgan on the B2, because I know that there's been some discussion about why the court, or why the legislature used the word liability instead of immunity. And this is what the Ramirez court had to say on that point. The failure of an individual officer to execute a written certification does in fact operate to impose liability on a public agency when it makes immunity unavailable for a claim in which the agency would otherwise be liable. Thus, the Morgan court's interpretation fails to give effect to the plain language of the statute. I also want to say, with respect to the interpretation of that last sentence, that if the court accepts the city's interpretation, it is dispositive in the city's favor. If the court accepts the appellant's interpretation, that the sentence has nothing to do with immunity, it's irrelevant, and it provides no support for the appellant's position that 100% is required. And then to address... I saw someone else do that.
I think everybody this morning has done that.
I'll pull my notes back right. To address post just briefly, I want to point out that actually the statute does not incorporate post standards for promulgation. The statute makes no reference to post or to the penal code section that is post, which is a long number, with respect to the promulgation requirement. Post is not mentioned in subdivisions B1, which sets forth the promulgation requirement, or in B2, which defines promulgation. The only reference to post guidelines is in subdivision D, which defines training as training that complies with post guidelines. Furthermore, whatever guideline it is that council is referring to from post is informal responses to questions on a website that says, and it does not say 100%, it just says agencies should keep track of their own attestation forms and don't send them to us because we don't want to be responsible for them. And it also says, I forgot what the other thing was.
Something else.
Something else. Thank you. If there are any other questions, let me just make one final statement, and I will submit. There is no 100% officer certification requirement in Section 17004.7, and such a requirement would be unworkable, even impossible. It would frustrate the statute and sacrifice the value to be gained by agencies adopting good policies and training their officers on good policies at the altar of an impossible documentation requirement that the statute does not impose. The answer to the question is no. 100% certification is not required for agency immunity under Section 17004.7. And in this case, specifically, the City of Gardena complied with all three of the requirements for immunity: adoption, training, and promulgation. The city adopted a policy that the trial court and the Court of Appeal found complied with the requirements. The city trained its officers annually, and the plaintiff has never challenged the adequacy of the city's training program. And lastly, the trial court held that the city established that it promulgated its policy, and the Court of Appeal found that there was no dispute that the city actually had a requirement that all its officers execute the requisite certification, and noted that the plaintiff did not controvert the existence of the city's certification requirement, but claimed only that fewer than 100% of the officers certified. The court should find that the city's efforts satisfied the statutory requirements for immunity and affirm the summary judgment in favor of the city. Thank you.
Thank you, counsel. Mr. Nabi, you have 4 minutes.
Thank you. With regard to whether this is, assuming for a second that this really is just a requirement, meaning someone has just to stand up and say, hey, everybody, this is what you have to do, okay? Then what's the point of the writing and the certification requirement in the statute? What's the purpose of it? If all they have to do is stand up and announce, everybody must do this, and that's the end of it, what's the purpose of it? The purpose of it is to make sure that it's done. The legislature wanted it, Post wants it, the statute definitely seems to want it, because it wants everybody to do it. It wants everybody to write it down and certify it. That's the whole point of the statute. With regard to what it is that the city of Gardena did, they didn't even meet their own requirement. To read a sentence from their brief, the statute requires that the agency institute a requirement that all officers sign certifications. All. They didn't even meet their own. They got 81 out of 92. Over 10% didn't do it. So they didn't even meet their own supposed requirement. They didn't do it. They didn't do it in the year prior. They didn't do it in the previous years either. At best, we have 81 out of 92. Previous years, we have as little as 60 or 64. So they never met it. Even by their own standard, they didn't meet it.
Could you recapitulate your answers to, I think it was Justice Chin and others who asked about sort of the practicalities of new hires and the time frame within which this compliance must occur, so that at any sort of slice in time you might have less than 100% compliance.
Yes, yeah. I understand Your Honor's point, and I just want to be clear about this. The statute does give a specific timeline. It must be annual, meaning it must be a year, at least a year old by the time the incident occurs. Now, under our interpretation, we would provide the agency the entire calendar previous year. That would still constitute annual.
So any officer hired prior to a year hence, or a year prior, that would be the metric you would use to measure all.
Yes, the year prior. If someone was hired the year prior, that is when.
So you take out all the within 1 year hires out of the denominator, and you look at all the people behind them.
All the people that were employed and as full-time officers in the previous year.
Can I just ask you, the annual time frame, are you getting that from the discussion of the training in the statute, or is that separately applicable to the written certification? Because I'm looking for that in the statute, and
I believe it's.
I'm quoting here from B2. It says a requirement that all peace officers of the public agency certify in writing they have received, read, and understand the policy.
I believe it's E or D. It states that it shall be annual. That regular and periodic
applies
training.
Just to the written policy or to the training as well?
Well, the only thing, that's the thing. The only thing that matters here is the written certification, presuming that they trained. That is the evidence of the fact that they trained. That is the only standard the legislature is looking for. I still go back to the issue of this is something that must be worked for. This is not something that is implicitly given to them. This is something they have to strive to. That's why that last sentence is in subsection B2. It is discretionary. If the department does not want to do this because it may present an administrative burden, they don't have to. They just don't get the immunity. And what that sentence provides is you can't use their failure to certify all their officers in order to establish liability. It is not an issue of saying, oh, it means less than all. What it says is that if you do not meet this, then fine, you will not be penalized. That is the balance that counsel was referring to.
I understand that point is clear, I think. But so just to go back to Justice Krause's question, so the term annual, are you pointing us to D, subdivision?
I believe it's D. It says
that just says regular periodic training means annual training?
Annual training, yes, Your Honor.
Okay.
So by annual, it cannot be within the same year of the incident. It must be the year prior. That would make it annual, meaning the training must be completed within the year prior.
Mr. Anabe, your time has expired.
Thank you, Your Honors.
Thank you. Thank you, ladies and gentlemen. The court stands in recess.